Thank you all for making time to attend our second webinar on part 2 of the two-part series on judicial decisions. Thank you. My name is Anthony Alex, and today we will be discussing 3 important cases that have sort of been, that are, worthy of discussing for everything related to POSH, the POSH Act and the POSH law in general, with an important case, Anita Suresh versus Union of India and others. Important because this deals with, false complaint. So let's dive straight in. Anita Suresh versus Union of India. This case pertained to, the complaint. The facts were as follows. The complainant was working with the ESI Corporation in Gurgaon. She filed a complaint with her internal committee alleging that the respondent had made sexual advances towards her in the presence of other colleagues. The complainant alleged that the respondent had asked her to come along to the male toilet to check the shortcomings when nobody else was around, right? The IC conducted an examination and they asked the complainant to actually provide the names of the witnesses who she had, because the complainant had said that this incident happened in front of a number of her colleagues. So the IC asked her, can you sort of name the colleagues who were there so that they could independently verify this case separately with them, right? So the complainant during examination was not able to recollect the names of the persons present at the time of the incidents, despite being shown the relevant papers relating to the staff members who present on that day of the incident, right? So the IC actually told her, listen, these are the staff members who were present on this day. Can you now go through this and tell us who you think was present when the respondent allegedly behaved in an inappropriate manner? She was not able to do that. So she was not able to produce a single witness, despite her own claim that this entire sort of harassment happened in the presence of her colleagues. The IC therefore dismissed her complaint. And dismissed the case against the respondent. So the respondent was found not guilty and the case was closed. The complainant then subsequently filed a complaint before the Delhi High Court, and where she challenged the order of the IC. Interesting. So the Delhi High Court heard the matter, and here's how they decided the matter, whether the court actually did the right thing in this instance or not, right? But let's go for the judgment order of this court. So the Delhi High Court, a single judge of the Delhi High Court, observed that it was hard to believe that the complainant could not remember the names of any colleague or staff member who had witnessed the alleged events, given the sheer nature of the offense, right? So given the seriousness of the offense, given the fact that the complainant is saying she was humiliated in front of her colleagues, the fact that she could not remember or recollect the name of even a single witness was viewed very seriously by the Delhi High Court. The IC had examined all the relevant persons on duty on the day of the incident. So thereafter, the court also added that the complainant at no point had specified or provided any details of the comments before the IC. So the High Court termed the complaint filed by the complainant to be false and to have been filed with an ulterior motive to defame the respondent, right? So the High Court felt that in view of these circumstances, they felt that the complaint was actually a false and malicious complaint and dismissed with the objective of defaming the respondent. And they dismissed the petition by ordering the complainant to pay 50,000 to a welfare trust as penalty for filing a false complaint. So if you all recollect, the POSH law 2013 actually says that the penalty or the penal consequences of filing a false complaint is as severe as it were if one had been guilty of sexual harassment. What are the takeaways? In cases where the IC concludes that the complaint is filed as false and malicious, it can find the complainant. So that is exactly as per the POSH law. Now remember this, that in this case, though the IC did not find it to be a false or malicious complaint, the High Court did. The IC had simply dismissed the matter, right? But the High Court, upon hearing the facts and looking at the order of the IC, came to the conclusion that it was a false and malicious complaint. So, and as you know, the POSH Act provides for the same penalty in case of a false complaint as in the case of sexual harassment. So the next case is the Usha Padmini case, Usha Padmini versus State of Karnataka and others. It's a Karnataka High Court single judge decision. The facts were as follows. The complainant and the respondent were both working at Alcatel-Lucent Technologies. The respondent was a reporting authority or manager of the complainant. The complainant filed a complaint with the IC alleging that the respondent had been sexually harassing her by sitting inappropriately in front of her and on occasions standing too close to her. The IC completed the inquiry, but they absolved the respondent of all charges, right? So the respondent was found not guilty in the report that they submitted to HR. Post the IC's mandate or the order, the company terminated the services of the complainant. The complainant filed a criminal complaint, following which a charge sheet was filed against respondents under Section 354A, 504, read with Section 34 of the IPC. Essentially, sexual harassment as a criminal offense, right? The complainant also challenged the order of the IC before the High Court and the Supreme Court, right, where the petitions were dismissed on the grounds of non-maintainability, which basically means that both the High Court and the Supreme Court refused to accept the appeal filed by the lady with respect to the IC's order. Why this order is important is as follows, right? The Karnataka High Court placed reliance on the Supreme Court's judgment of Radhesham Kejriwal versus State of West Bengal, which states that in a case where following an inquiry, the respondent has been absolved of all charges, a separate criminal prosecution on the same set of facts and evidence cannot be allowed. Therefore, what the Supreme Court had said in that case is that if there was in a separate civil proceeding, the case that has been charged against somebody and has been dismissed, then on the same set of facts, one cannot file a criminal complaint. So this was the Supreme Court order that the Karnataka High Court relied on, right? The High Court held that the IC's inquiry was concerning the same allegations made again in the form of criminal prosecution under 354A of the IPC. The court noted that the material relied on by the IC and the investigating agency is the same, and that the complainant had not produced any additional material to substantiate the said charges. On the same set of facts, a fresh complaint or a criminal complaint is filed, it is likely to be dismissed. It was observed that after having the IC already inquire into the very same allegations and having found no truth or substance in the said allegations, prosecution of the respondent for the very same violation on the very same set of evidence would be an unjust and an abuse of the process of the court. The court believed that under the said circumstances, to secure the ends of justice, it would be necessary and expedient to quash the proceedings initiated against the respondent. The proceedings initiated against the respondent for the offences punishable under sections 354A, 504, read with 34 of the IPC were hence quashed, which means the court completely quashed the proceedings, and therefore the criminal proceedings completely came to a standstill. 1. If the respondent, following an inquiry, has been exonerated by the IC of all charges and been declared as innocent, a criminal charge with the same set of facts and evidence will not be held valid in the eyes of the law. The aggrieved woman or the complainant may approach the appropriate forum in case of a grievance, but at the same time cannot be allowed to forum hunt for favorable relief. This judgment reinforces the importance of the IC inquiry process and the subsequent order. Very, very important for all of us to appreciate and understand, especially those of us who are members of an internal committee. You have a very important role to play and a job to do, which is ensuring that justice is done. Because on the basis of your order, either the complainant or respondent, the next steps that they may take in the legal process, really a lot of it depends on your order. And the IC's order is really a trial court's order. Higher courts view it as a trial court's order and give it that sort of respect and importance. And the last case that we're going to dive into before we close out all three cases is the Union of India and others versus Rema Srinivas Iyengar. This is hot off the shelf, if you will. It's a brand new order. It's just come maybe weeks ago. passed by Madras High Court and a division bench. If you notice, the first two orders were passed by single judge, a single judge bench, single judge, but this is passed by a division bench, two judges sitting in a division bench. So in this particular case, the complainant had filed a case against a superior officer, the respondent, with the Registrar and Controller General of the Trademarks and GI and Patents and Design, right? The complainant claimed to be aggrieved by the high-handedness of the respondent and the harm that it had caused to her self-respect due to his arrogant behavior, okay? The registrar constituted an IC to look into the complaint filed by the complainant. Subsequently, the complainant filed another complaint highlighting other incidents involving the rude behavior of the respondent. The complainant then wrote a letter to the Tamil Nadu State Commission for Women, stating her apprehension that the IC would not render justice to her, since all IC members were subordinate to the respondent, and therefore her complaint should be referred to the local committee. The letter had a different set of facts compared to the original complaint, which had been filed before the IC, suddenly mentioning several advances and instances of sexual harassment. The local committee constituted a committee that looked into the alleged grievances of the complainant and recommended an immediate detailed departmental inquiry against the respondent by his employer. The complainant also approached the Central Administrative Tribunal, CAT, stating that she had no faith in the IC of a company. So basically, the complainant is now filing complaints left, right, and center in multiple fora. The CAT held that the local committee had already conducted a preliminary inquiry and that the IC formed by the employer is against the law due to the sole reason that the respondent himself was the head of the department, right? And therefore, all the people who were on the committee were junior to this particular individual. Therefore, a complaint against him can be inquired into only by the local committee. The decision of the tribunal, the CAT, was challenged before the Madras High Court by the respondent. The Madras High Court came down heavily on the complainant and opined that the complaint filed by her lacked details of the alleged incidents and was too generic. So if you remember the first part of what we discussed, the details, it did not contain details with respect to the sexual harassment that a complainant had suffered. The High Court observed that how the complainant had gone about the routine of filing several complaints appeared to be an afterthought. It was opined that the local committee had given an erroneous decision via a non-speaking ex parte order. So in this case, this is a fairly tangled, complicated case. But in this case, what had happened was that the local committee had asked the respondent to appear before it. But apparently it had only given it one opportunity to appear before it, and then thereafter proceeded to file an ex parte order. The court held that every office has to maintain a certain decorum, and women employees cannot be allowed to go scot-free without completing their assignments. That the administrative head or chief has every right to extract work and has his or her own discretion and prerogatives. So the court is basically saying that this is now boiling down to the head of the department is being allowed to do whatever he or she needs to do to get the job done, right? So the court does not feel that there is anything, it's not a POSH issue. Actually, the court also does not even feel that it's an HR issue. It just feels that if the head of a department or a company is not given a free hand to get the job done, then work is going to suffer. And hence, they felt that it was a case of a departmental head just trying to get the work done from a subordinate. So, if a woman employee is discriminated against due to her inefficiency or for any other official reasons, the recourse for her is not the one taken by the complainant of this case, which means you cannot file a POSH complaint just because you're aggrieved by the manner in which your supervisor is sort of behaving vis-a-vis you. The court held that even though the POSH Act intends to have equal standing for women in the workplace and to have a friendly workplace in which their dignity and self-respect are protected, it cannot be misused by women to harass someone with exaggerated or non-existent allegations. The High Court therefore quashed the charges and the ex parte order, which had been passed by the LC, against the respondent and exonerated him of all charges. So, what's a key takeaway? Pulling up an employee for completion of work and trying to get them to finish the assigned work cannot be termed as sexual harassment. Usage of one intemperate language cannot come under the purview of the POSH Act. Essentially, speaking badly maybe I would say even not just one, maybe speaking badly twice or thrice also, as long as there is no sexual intent, or if it is not a retaliation for previously sought sexual favors, in which case that would amount to retaliation, then it would not amount to an offense under the POSH law, right? So this is also a very important case that was recently decided, and something that we thought would be useful to share with all of you. All right, so that brings us to an end of today's session. It's a short one. We wanted to just basically share these cases with you.